Meeting of Privileges and Elections is called to order. If the clerk would call the roll, I'd appreciate it.
I will, here we go, she's going. Mr. Chairman, you have a quorum.
Okay. We have a quorum. We only have 13 bills, and 2 of them are bills that are identical to what we've seen before. 2 of them are similar. The rest are basically different. Some are contested, some aren't. What I'd like to do is we've got members that have to leave by 3:30. Of course, there's not a time limit on the end of the meeting, but I don't think it should take an hour. So let's go from the top of the docket. House Bill 1890, Delegate Price, is identical to a bill that Senator McClellan had. I don't know if she's here. 1395 that passed out of here on a 9-6 vote. It passed the Senate on a 21-17 vote. Delegate Price, are you there?
Yes, Mr. Chairman, I'm here.
Is that right? This bill is identical to Senator McClellan's bill?
Yes, Mr. Chairman, it is identical to 1395.
Okay, and it's basically it prohibits discrimination in certain election administration. Is there anything you want to say about the bill?
No, I can answer any questions, but it is the exact identical bill.
Okay, we had this bill before.
Second.
Got a motion and a second to report the bill. Any further motions? Any more? Okay, the motion is to report and refer to finance.
Yeah, Janet got all the money Janet got now, so she can't do it now.
So, are there any further motions or any further discussion? If not, please open the roll. Strike the roll. Who?
No. No.
Okay.
I don't.
Okay.
I was trying to let Senator Boysko get to her seat.
Okay. Please open the roll.
Ayes 7, noes 5.
Okay, ayes 7, noes 5. The bill reports. Thank you, Delegate. The next bill on the docket is House Joint Resolution 582, which was identical or similar to Senate Joint Resolution 270 that Senator Eben carried with respect to marriage. Delegate Sickles, are you on the line?
Delegate Sickles is not on the line,
Mr. Chairman?
Senator Eben.
I would say it's not similar. It should be identical. Was my understanding that our wordings were identical last I looked at it.
Okay, well, the one question I had was something we really talked about on the floor, Senator Eben. The way this is worded, let's see, Senator 582. The way this is worded on, I think I've already missed it. Let's see. On lines 18 and 19, 18, 19, and 20, does this include, for example, if I wanted to marry my sister or my 13-year-old neighbor's daughter?
No, I would say I think it's particularly clarified if you go down to line 25 and 26, where it says that they shall issue marriage licenses, recognize marriages, and treat all marriages equally under the law, regardless of the sex or gender of the parties to the marriage. It doesn't say that they would do that based on any kind of familial relationship or anything. I think that marriage in the code is defined who you can't be married to.
Yeah, I get that, but this overrides the code. We're right in the Constitution.
Right. It does, but it doesn't say it's a fundamental right to marry anyone regardless of. I mean, there's some common sense there. It doesn't say that it. I think the fact that it says regardless of the sex or gender further down It does not say regardless of the familial relationship or that sort of thing.
I'd like to hear from counsel. This language on line 18, the right to marry is a fundamental right inherent in the liberty of persons, and marriage is one of the vital rights essential to the orderly pursuit of happiness. I agree with that. I'm just wondering if that language would have the effect of giving people the right to marry someone that they're related to, and what we would consider to be an incestuous relationship right now, or someone who wasn't an adult. Brooks, are you out there?
Yeah, Mr. Chairman. Yeah, the wording as it is, I don't know whether a court would or would not do that. There are other rights that we have in the Constitution, for instance, free speech, but that doesn't mean that you have an unlimited right to free speech. There are laws that abridge that, like not being able to scream fire in a crowded theater that would, protect the public otherwise. So I don't think it would necessarily be if the law otherwise provided that there were restrictions on that to protect the public, wouldn't be out of bounds because of the wording.
Okay. Mark Sickles, you're in the room now. Is there anything you want to say on this bill?
No, I understand that Senator Eben has spoken. I believe that the bill that, and I hope I'm right about this, the resolution that passed the Senate is the same exact version and is now before this committee.
Okay. Are there members
Am I correct about that?
That you're correct. Are there members who have questions of Delegate Sickles? Are there folks in the public who want to speak?
If you would like to speak in support of the bill, please raise your hand. I see one, Mr. Chair.
Okay.
V. Denise Harrington.
Okay, go ahead, Ms. Harrington.
Thank you very much. My name is Denise Ricks Harrington, and I'd like to speak in favor of the bill, HJ 582. And I'm with the League of Women Voters of Virginia. The League of Women Voters of Virginia supports repealing the constitutional provision defining marriage as only a union between one man and one woman. And we support all marriages being treated equally under the law, regardless of the sex or gender of the parties to the marriage. The League also hopes the General Assembly will consider that the civil status of marriage is already clearly distinguished from the religious institution of marriage, and that religious rights will be preserved without additional language. Thank you very much.
Okay, thank you very much, ma'am. Is there anybody else in favor?
Yes, Mr. Chair, I believe Joanne Collins would like to speak to this.
Okay, Ms. Pons.
I'm sorry, I'm in the wrong room.
Okay, are there people that are, is there anyone else, or are there people opposed to it?
If you would like to speak against the bill, please raise your hand. I see no hands, Mr. Chair.
Okay, well, the bill is before the committee. It's in exactly the same shape that was Senator Evans' Senate Joint Resolution 270 was. It passed out of this committee 9-4 to 2.
Move to report.
Second.
There's a motion and a second to report. Are there further motions? Is there further discussion?
Mr. Chairman.
Senator Donovan.
Thank you, Mr. Chairman. I am listening to what you have said earlier in the meeting, and I'm hearing statements earlier about the language being put in, and I'm going to make a substitute motion to amend the bill to strike lines 18 through 20.
So is there a second to that motion? That the motion would strike the language that begins the right to marry and would end with happiness on line 20. There's a motion and a second. All in favor of that amendment, say aye.
Aye.
Opposed? No.
No.
Okay, I think the noes have it, but to be safe, why don't we call the roll? Open the vote, yes.
7 noes, 7.
Okay, the motion fails on a tie vote. Back to this, I guess the original motion was to report. Was there a second to that? There was a second to that motion. So is there further discussion on that motion? We'll open the roll, please.
Ayes 9, noes 4, 1 abstention.
Okay, that bill reports. Now we're going to two bills that are similar but not identical. The first one is House Bill 1888, and there is a substitute for that bill, and I think it's available to you on, maybe it's already been circulated, but I think it's on
Vote on that?
LIS. There was a second to that motion. So is there further discussion on that motion? So is there a motion to adopt the substitute?
So move.
Okay, there's a motion and a second to adopt the substitute for House Bill 1888. All in favor, say aye.
Aye.
Okay. House Bill 1888 combines the provisions of two bills that I carried, Senate Bills 1245 and 1246. The controversial parts of this bill are the drop box and the ballot cure provisions. You will recall it passed out of this committee on a partisan vote. There are some other provisions of the bill, and I think Delegate Van Valkenburg's on the line if you want to speak to the bill. But most of it you've already seen. There is one other provision I want to explain. There is an enactment clause at the end of the bill. The committee will recall that Senator Suderline had a bill that would have required local boards of elections to break the absentee votes down into precincts. Well, the elections community says we just can't do that. We don't have the technical wherewithal to do that. There's an enactment clause in this bill. The House killed Senator Suderline's bill. The enactment clause of this bill sets up a study committee to take a look at that issue and report back before the next session of the General Assembly. Delegate Van Valkenburg, would you like to address your bill?
Mr. Chairman, I'm getting a text from Delegate Von Valkenburg that they're not getting sound in the waiting room. He couldn't hear you. Let me ask him to try and speak up.
Delegate Van Valkenburg, are you hearing me? Do we have a technical problem?
I heard from someone else who's a witness that the committee room with the witnesses seems to be muted.
You're muted.
Testing.
Oh,
Delegate Van Valkenburg, can you hear me?
Okay, yeah, you guys were on mute. We only heard that you were calling up 1888, and we didn't hear anything after that.
Well, we called it up. We adopted the substitute. We explained parts of the bill, and I asked you if there was anything you wanted to say, and I apologize that you couldn't hear us.
If you explain the different parts, I guess I would just defer to what you said, and then if anybody has questions, I would be glad to answer.
I didn't really explain the parts that weren't in the two bills I carried or Delegate Suderline's bill.
Okay, yeah, so thank you, Mr. Chair. I'll just explain that real briefly. So the core of 1888 is similar to 1245, which is the chairman's bill. It does four things that the chairman's bill does not. The first is prepaid postage, which was also part of the special session package we had. So that's one. The second thing is an enactment clause. If you remember last year, we passed two absentee voter kind of rolls, one that allowed you to be an absentee voter for the year, and then that was going to be taken over by a permanent absentee voter list. And so the enactment clause would allow the Department of Elections to roll that list over, but notify folks so that they could opt out. The third change.
Excuse me. So the Suderline enactment clause was put on my bill in the House of Delegates, right?
Correct.
Okay.
Correct.
I apologize to the committee for that. I gave
Correct.
you bad information.
And And then the third change, which is a lot of text, but is actually kind of pretty straightforward. We had a lot of people who applied for absentee, but then for various reasons, like a fear of the post office, decided they wanted to vote in person. And so this bill lays out the kind of procedure for if that happens, when you vote provisionally and when you can just vote regularly, so that there's kind of clarity for the voter and the registrar and the election worker. And then the fourth change is kind of what we call the election night procedure thing, where Mark Warner's declared the victor at 7:01, but at 11 o'clock on your TVs, it still says he's losing. And so this bill tackles that in two ways. First is it splits in-person early voting from absentee voting so that they're tallied separately, so that early in the night the in-person early voting can be put right into the system. And the second thing it does is it mandates that the registrars process absentee votes starting 7 days out from the election. And it says that they may start processing them at noon so that we can get those absentee ballots also brought out to the public earlier.
Are there any questions for Delegate Van Valkenburg? Okay, are there members of the public that would like to speak to this bill?
If you would like to speak in support of the bill, please raise your hand.
I can't.
Okay.
Right now.
Okay.
Alexandria Bratton.
Ms. Bratton, if you'd go ahead, I'd appreciate it.
Good afternoon, Mr. Chairman and members of the committee. My name is Alexandria Bratton, the program manager for the Virginia Civic Engagement Table, and we strongly support this legislation.
Okay, thank you very much. Is there anyone else?
Yes, Mr. Chair, I see 4 additional speakers. We have Lisa Stave. Please
Well,
go.
if you're for the bill, I'd ask you just to identify yourself, identify your group, and tell us what you're for, but don't take too long.
Lisa.
Mr. Chairman, Lisa Stibe with the Virginia Education Association. We support this bill.
Okay, thank you very much, Ms. Stibe.
We have Allison Robbins. Please go ahead.
Ms.
This
Robbins.
is Allison Robbins. I'm the president of the Voter Registrars Association of Virginia, and we strongly support this bill. Thank you.
Thank you very much.
And finally, Katie Boyle. Please go ahead.
Thank you, Mr. Chairman and members of the committee. I'm Katie Boyle with the Virginia Association of Counties, and we don't really have a position on most of this bill, but I would just say with respect to the requirement to provide the prepaid postage, really want to thank the legislature and the administration for funding this requirement during the November 2020 election. Figures that the department had provided to me indicate that that was about $940,000 in costs that the state bore. So not a trivial cost for local governments. This bill would make that requirement permanent. So we would ask that the state continue that commitment to supporting localities and meeting this policy goal. I want to thank Delegate Van Valkenburg for working very hard to secure some language in the House budget that would allow some unused funds that were not used for the November 2020 allocation to pay for that postage. So really appreciate that. And so just in closing, I would say this is an opportunity for the state to assist localities in a concrete way towards meeting some of the state's goals of making Virginia elections more robust. And so we would just implore you to look favorably on providing the funding to move in tandem with this requirement.
Okay, thank you, Ms. Boyle. I think the funding is left over from this past year. I think it's still in the budget. Isn't that correct, Madam Chair?
I believe so.
I think it is, yes. Okay, are there others in favor who need to speak, or those who have a contrary view?
Lisa Coteen Gerchik, are you speaking in support of the bill?
Okay. Yes, ma'am.
Mr. Chair, members of I'm Lisa Coteen-Kirchnick of the League of Women Voters of Virginia, speaking in support of HB 1888.
Okay, thank you,
The
ma'am.
League urges you to make permanent the temporary provisions for drop-off locations
Yes, ma'am.
and ballot curing that affect.
Yes, ma'am. Thank you very much. Are there others?
You're welcome.
Mr. Chairman, move the report.
Okay. Got a motion and a second to report. Are there other motions or further discussion? If not, please open the roll.
Ayes 9, no 6.
Ayes 9, no 6, the bill reports. The next one is House Joint Resolution 555 from Delegate Herring, who's on the line. Delegate Herring, this bill is similar to an automatic a different point of view that Senator Locke has taken, and it might not be all right, but I think what we're going to do is adopt a substitute that conforms this bill to Senator Locke's, and then you all can work it out in conference. Is that okay?
That is fine. I spoke with Senator Locke yesterday, and so that goes along with our plan. I appreciate it.
Well, I would entertain a motion for a substitute that would make this bill identical to the.
Second.
Okay, all in favor of adopting the substitute, say aye.
Aye.
Okay, do I have a motion on that? I think we just had this bill a few weeks ago.
Move the report, Mr. Chairman, as amendment.
Okay,
Same as Locke's bill.
Senator Locke, it reported 10-5 and passed out of the Senate 22-15. Is there further motions or discussion? Are there people in the public that feel like they need to say something?
No.
If so, please raise your hand.
Come on, Mr. Chairman, you're wasting time.
You gotta let.
I see two hands, Mr. Chair.
Okay.
Claire Gastanaga, please go ahead. Claire Gastanaga, please go ahead.
Claire.
Mr. Chairman, members of the committee, thank you for letting me speak for a moment. I just wanted to.
30 seconds, okay?
I've got it. I just wanted to encourage you to think again about the possibility of amending this provision back to the thing that you voted out of this committee 10-5.
And we just did that, Claire. We just did that.
Mr. Chairman, you did not. You amended it to be the Senate floor substitute.
Okay.
The ACLU feels strongly that SJ 272 as introduced is the right to vote provision that we hope you would support. And we would have been happy to have you conform HJ 555 to Senate Joint Resolution 272 as introduced, as opposed to as amended on the floor.
Okay.
And I've used my 30 seconds, but I just wanted to make that point.
Thank you very much, yes. I apologize because I didn't remember that step in the process. I apologize. Is there anyone else?
Yes, Mr. Chair. We have Denise Harrington.
Okay, Ms. Harrington.
Yes, thank you very much. I was going to concur with, I have Denise Harrington with the League of Women Voters of Virginia. So I was going to concur with what Claire Castaneda said as well. If we could conform HJ, the League of Women Voters position is that they do not oppose necessarily HJ 555. However, we maintain voting is a right that should not be stripped away and so would not need to be restored if we remove the Jim Crow provision. So it seems as if you all are going to go into conference and work on that. However, we also supported the SJ 272 the way it was originally mentioned.
Okay, thank you very much. Are there others?
Yes, Mr. Chair. Our final speaker is Richard Walker. Please go ahead.
Yes, Mr. Chair, I concur with Constantiniga as well as Ms. Harrington that we prefer the HJ 272, but in conference, we are hoping that they will come together, that it'll have the language as it is in HJ 272. Thank you.
Okay, are there further motions or need for discussion? If not, please open the roll.
Ayes 9, no 6.
Ayes 9, no 6, the bill's reported. Next, we have 3 bills that came through from the House of Delegates uncontested. Of course, that's no predictor of what's going to happen over here. But the first one is House Bill 1810 from Delegate Van Valkenburg. And Delegate, I think you're still on the line.
Yeah, thank you, Mr. Chair. Members of the committee, House Bill 1810 allows the governor, if voter registration drive goes down, or online portal goes down, something we've seen in the last 2 presidential elections, it simply allows the governor to extend the deadline by a day plus a day for education, which is what's happened in the last 2 presidential elections. So in the last 2 presidential elections, the system has gone down on the day when registration was to end. And what's happened is we've been taken to court, and we've had a consent decree, and in the consent decree, they extend the registration by a day and then another day for education. And it's costing us money because we have to go to the courts, and this just allows the governor to do it on his own.
Okay, does everybody understand the bill? Does anybody have any questions of Delegate Van Valkenburg? Are there those in the public who need to speak? I apologize. Senator Peake, did you have a
I
question?
do have a question. Thank you, Mr. Chair. Delegate, as far as what are the criteria for the emergency? Just that it shuts down? How do we define that, or is it defined?
On line 21, it says, in the event that a failure of the Virginia online registration system occurs prior to the close of registration records. I think that's the emergency they're talking
It's
about.
just going to be failure, and I just.
Is that it, Delegate Matt Valkenberg, or are there other emergencies?
Yeah, Mr. Chair, members of the committee, it's if the system goes down for an extended period of time. What happened in 2020 was that a internet wire was cut in Chester, and it caused the whole system to crash for a day.
Yeah, Mr. Chair and Delegate, yeah.
Senator Peake.
I approve of that thought. I just somewhat concerned of the vagueness of how long it may be down or what we actually consider down, but I think I approve. I understand what you're trying to do.
Are there other questions of the sponsor?
Mr. Chair,
Delegate McClellan, Senator McClellan, I apologize.
I guess hopefully this will give Senator Peake some comfort, but it does make clear that the extension is for the amount of time that the system was unavailable. So it's a limited amount of time.
And that language is on line 24. For a period of time, you can extend it for that period.
It does have guardrails on it,
Yes,
Mr.
it does.
Chair.
Yes. Are there other questions for the patron of the bill? Are there those in the public who need to speak to this bill?
If you would like to speak to the bill, please raise your hand. Alexandria Bratton, please go ahead.
Yes, Ms. Bratton.
Thank you, Mr. Chairman and members of the committee. Alexandria Bratton again speaking on the Virginia Civic Engagement Table, and we support this bill.
Okay, thank you very much. Are there others?
Yes, Mr. Chair, we have Allison Robbins.
Ms. Robbins?
Allison Robbins, President of the Voter Registrars Association, and we strongly support this bill and encourage the committee to pass it.
Okay, thank you very much. Are there others?
No, Mr. Chair.
Okay, the bill is before the committee. What's your pleasure?
Second.
Okay, got a motion and a second. Are there further motions? Is there further discussion? If not, please open the roll.
Who has sent voice go? Senator Servo. Okay. Ayes 13, no 0, 2 abstentions.
Okay, Delegate Van Valkenburg, you've had a very good day. I'd suggest that you leave before it's too late.
Thank you, Mr. Chair.
Delegate Price, you've got House Bill 1921. You're still on the line.
Yes, I am here, Mr. Chairman.
Appreciate it. Yes, ma'am.
Yes, so this bill is about curbside voting. As many of you know, it is available for those who may be disabled, injured, and more recently, some localities made it available for those of us that are high risk during the pandemic. But there are folks that use it that have encountered major challenges, like not being able to stay curbside in order to vote curbside because you have to go inside to let the staff know that you'd like to vote curbside, or have someone with you that could do that. So what House Bill 1921 seeks to do is allow people to vote curbside and be able to stay curbside. And so it gives a requirement for localities to post how they can let the staff know that that's what they would like to do. And the language would be determined by the department. It also clarifies that curbside voting is available for those that are 65 or older, permanently or temporarily disabled, and those who have an injury, and that in a health emergency like the one we are in now, curbside voting would be available to any voter who wished to use it. So it's just raising the minimum standards of accessing curbside voting. And just want to give a shout out to the Disability Law Center of Virginia, who worked with me on this legislation. I hope that you would move the bill forward.
Are there questions of the patron of the bill?
Mr. Chairman?
Senator Spruill.
We do that now. I think this is a good bill. And we do that now on curbside when they come outside. They don't have to go back inside. Once the person inside know about it, they come outside, let them vote right there at the call. So we do that now. So this is a good bill.
It is a good. Okay, are there other questions of the patron? Are there people in the public who need to speak?
Yes, Mr. Chair. Christine Germeyer, please go ahead.
Yes, ma'am.
Mr. Chairman, members of the committee, my name is Christine Jarmeyer with the Training Alumni Association, and we strongly support House Bill 1921 as it would help to ensure that people with disabilities in the Commonwealth can exercise their constitutional right to vote curbside without barriers at any polling place within Virginia. I thank you for your time.
Thank you very much. Are there others?
Yes, Mr. Chair. Director Miller, please go ahead.
Good afternoon, Mr. Chair. Colleen Miller from the Disability Law Center of Virginia. I'm just available to answer any questions that anyone on the committee might have. We absolutely support the bill. We thank Delegate Price for bringing it.
Well, thank you, Ms. Miller. Are there other people?
Yes, Mr. Chair. We have 4 additional speakers. We have Lisa Coteen-Gerchik.
Is everybody who's going to speak in favor of the bill?
If so, please raise your hand. I believe so, Mr. Chair.
Well, I'd ask you just to identify yourself, and if you're if you have a group, you're representing a group, tell us who that is, and just tell us you're for the bill, and that'll be enough. I don't think there's any difficulty with this bill.
Lisa Coteen-Gerchik from the League of Women Voters of Virginia. We support this bill.
Okay.
Support B 1921.
Thank you very much.
Thank you, Mr. Chair.
Alexandria Bratton, please go ahead.
Alexandria Bratton with the Virginia Civic Engagement Table, and we support this bill and thank Delegate Price for bringing it forward.
Thank you very much.
Michael Olex, please go ahead.
Mike Olex with the National MS Society, and we support this bill.
Thank you very much.
And finally, we have Lisa Stave. Please go ahead.
Lisa Stibe of Virginia Education Association, we support.
Thank you very much. Are there people opposed to it?
If so, please raise your hand.
Okay, the bill is before the committee.
Move the report, Mr. Chairman.
Got a motion and a second to report the bill. Are there further motions? Is there further discussion? If not, please open the roll.
Ayes 15, no 0.
Congratulations, Delegate Price. You've done a great
Thank you,
job.
sir.
Okay, Delegate Simon has a bill 1952, I think, and it came out of the House uncontested. I think it might have some folks that are interested in it, but Delegate Simon, are you on the line?
I am here, Chairman Deed.
Okay, please tell us about the bill.
Mr. Chairman, members of the committee, what this bill would do would close a legal loophole that I think was created several years ago, unintentionally, when we reorganized the Virginia Campaign Finance Act, and subsequently, after the change, Attorney General, then Attorney General Ken Cuccinelli opined that the way we had written the code, it was only unlawful to convert campaign funds to personal use at the end of your campaign when you were winding it up, because that's where we had an explicit prohibition. And we didn't have an explicit prohibition on converting personal funds to campaign use anywhere else during your campaign. So we had an Attorney General's opinion that came out, or not an opinion, but a letter, memo, explaining the statute, which said, yeah, you can use personal funds anytime you'd like. What this bill does is it takes that last line out of Section D, and we add a new section that's entitled Prohibited Personal Use, and it makes it unlawful for a person to convert money, securities, and so forth to their personal use or the personal use of a member of their family. We apply what's called the irrespective test, meaning that it's considered personal use if it was it's an obligation that would exist whether or not you were a candidate or an office holder. So if you have to spend money on something because you're running for office or because you're an office holder, you can use your campaign account for that. But if you had to pay for it otherwise, you can't. To get to the sort of really nitty-gritty questions about that, we empower the State Board of Elections to promulgate some regulations and questions and answers about it. So people, candidates and delegates and senators will have a place to go to get some clearance about what's allowed. And we also ask the Attorney General to issue a new letter now that we've updated the statute to replace the AG letter that said that personal use was allowed. Finally, Mr. Chairman and members of the committee, part of the reason this came up is, you all may know, a few years ago, the feds at the federal level, Federal Election Commission, issued a new reg that said that child care was now a permissible use of federal campaign funds. So we had a number of delegates that came to the General Assembly last year and said, that's a great idea. And they went to Brooks and they went to Meg and said, hey, draft me a bill that says we want that rule in Virginia that personal use of, or that campaign funds can be used for child care. And in order to do that, the first thing they had to do was draft a bill that prohibited the personal use of campaign funds so that you could carve out an exception for childcare. So that's essentially what this bill does. It says a baseline that says you can't use personal funds. It explicitly says that you can use them. The childcare is in fact for purposes of candidates, an expense that exists because you're out campaigning. You need to get that childcare, and you can spend it on that, and then leaves it to the Board of Elections and the Attorney General to fill in the gaps and flesh it out so that we aren't get tripped up by unintended consequences.
Let me ask you this, Delegate Simons. This question was raised to me with me today. I mean, I generally support your bill, but you know, if I'm paying myself mileage as a candidate, if I'm driving 100 miles one day to do some campaign work, and on the way home, I stop at the grocery store to pick up some groceries to take home, have I converted the gas money that I've paid myself to personal use?
So obviously, I can't tell you with 100% certainty you'd be safe there, but if you made the trip back and forth because you needed to be on the campaign trail, the fact that you stopped and had some incidental, personal stuff on the way, I don't think would change the nature of that expense. So you had to get from A to B. You're going to have to get all the way back. I don't think anybody's going to look at them extra quarter mile or so that you spent getting from the road to the parking lot of the grocery store to pick up your groceries.
Is that something that?
And if you were.
Is that something that a local prosecutor could look at and make a decision on one way or the other?
Well, the penalty, Mr. Chairman, members of the committee, the penalty for this is a $100 civil fine. So I think your maximum exposure in a case like that would be a $100 civil fine, similar to failing to turn in your reports on time or things like that. So it's not like it's going to be a criminal matter where you're going to be having to hire a lawyer and go to court over it.
Okay.
Mr. Chairman?
Senator Spruill.
Simon, my question is that we do a whole lot of knocking on doors. Let's say during the campaign time, and I have 15 people, we knock on doors, and we say we're going to break at 2 o'clock, and I stop by Pizza Hut and get 12 pizzas and give them to them. If I eat a slice, am I in trouble?
I would say, Mr. Chairman, to that example, again, the Board of Elections is going to promulgate some regulations so you can ask these questions in advance and get, because I wouldn't want anybody to rely on my answers today,
right.
2 years from now.
But I trust you. I trust you.
All right. Well, I'm a pretty good lawyer, so if I do say so myself, right?
Ayes and nays, ayes and nays.
Ayes and nays.
Thank you, sir.
I think you can eat a slice of pizza. You wouldn't be. You wouldn't be throwing the pizza party if you did not need to be out there as a candidate knocking doors. The pizza is there as a nice thing to do for your folks. And I think you can join them for a slice of pizza and without running afoul of this particular statute.
Thank you, sir.
Although it could become an expensive slice if I'm wrong. It costs you $100.
Senator McClellan.
Thank you, Mr. Chair. I think theoretically this is not plowing any different ground than IRS regulations around what are business expenses versus personal expenses for tax deduction purposes. So I think the Board of Elections does have some precedent they can look at to answer some of the questions similar to what has been raised here, because all of those questions have come up in tax deduction contexts.
Mr. Chairman?
Senator Peake is next. Senator Eben, I'll put you on after Senator McDougal.
Thank you, Mr. Chair. Question to the patron. Is that
Senator,
yes, Senator.
Delegate Simon.
Are there any events in Virginia in the last couple years, 2, 3, where this is an issue?
So, Mr. Chairman, members of the committee, I would answer that it's really hard to know. There are cases that come up from other states and federally all the time. I've got a Google alert for personal use of campaign funds and investigations and cases. It doesn't come up much in Virginia because, frankly, there's no reason for anybody to investigate or look into it because it's not illegal. So you file reports and we can look through them and you'll see that somebody puts a big Wegmans grocery receipt on their campaign finance report, and maybe that's for their groceries or maybe that was for a campaign party. It says Pizza Hut. We don't know if it's for them or for their campaign, but nobody needs to ask any questions or wonder why because it's not illegal now. So, but frankly, it's not really the goal of this to try and solve a particular problem with a particular candidate or fix a particular incident. It's more of the larger issue that Virginia is, I think, the last state. Maybe there's one other out there that doesn't have an explicit prohibition on personal use of campaign funds. There's an optics issue, I think, with that an integrity issue. And so this is just to get us in the right direction and make it clear that the funds that come into our campaign accounts are to be used to further our campaigns and not to personally enrich ourselves.
Thank you, Mr. Chair. That was it.
Senator McDougal.
Mr. Chairman, thank you. And a couple things. I think it's a good goal to address the child care expenses because I do think that that allows individuals who have small children to be able to run when they might not otherwise be able to run. So I want to commend Delegate Simon for that. But being a not half bad lawyer myself, when I look at this language, it says to fulfill any commitment, obligation, or expense that would exist irrespective of the person seeking office. So, Mr. Chairman, people have to eat irrespective of them seeking office. So if Senator Spruill went to that, had a piece of pizza from that pizza party, under this language, it says in whole or in part. And so whether he had one piece of that pizza or the whole pizza, I think he would be in violation of the language as it is written. So, Mr. Chairman, I understand that others might have a greater comfort with the State Board of Elections promulgating these regulations, but if we're going to make it a penalty for somebody to be in violation, then it should be clear up front, and we should vote on what those penalties are. But I do think by using the terms fulfill any commitment, obligation, or expense, if Senator Peake stopped by and got by the grocery store, he would have been going to the grocery store regardless. So that would be irrespective of him seeking office. And if Senator Spruill ate that piece of pizza, that he would be eating dinner irrespective of being in office and could put him in violation.
Okay, Senator Eben.
I was just going to point out to the language on 46 and 47 about personal use does not include the ordinary and accepted expenses related to campaigning for or holding public office, to make it clear that those expenses are covered, obviously.
Okay, Senator Boysko.
Thank you, Mr. Chair. I just want to follow up on that as well. I mean, we know that having pizza with your staff is something that is regular and something that all of us do. Taking our treasurer on a trip to Jamaica is not something that would be considered regular. And I think that's the intent of the patron, is to make it clear that things should be within the parameters of regular campaigning. And I would be very surprised if someone's going to quibble over whether or not you picked up a sandwich for yourself while you're coming home from canvassing or sharing pizza with your staff. I think that those are really missing the intent of the bill, which is not taking your treasurer and or family to Jamaica on your campaign funds.
Okay.
Mr. Chairman,
Senator McDougal.
I'd point out that this would not prohibit you from taking your treasurer, paying for your treasurer's trip, because it only says immediate family. So it would not prohibit that. It would certainly prohibit you taking your family. And I understand that might be the intent, but that's not what the words say. So I'm in favor of the intent as articulated, but I don't think that's what the language of the bill actually says. And this language doesn't prohibit your treasurer from taking the trip to Jamaica with the campaign funds.
Okay.
Chairman?
Mr. Chairman.
Senator Surville.
Thanks. I got a question for the patron.
Okay.
So,
Senator Simon, Delegate Simon, you're going to get back into the swing of things here. You got
I'm
a
ready.
question.
Mr. Chairman, so I generally support the concept of this. I worry about people getting unduly caught up in it or potentially accused of breaking the law by people for certain uses. And for example, one question, one scenario in my head I'm bouncing around is I've seen, I don't do this personally, but I've seen some local government people use their campaign funds to pay for example, going to a party dinner, a political party dinner. And I can tell you that I would have gone to political party dinners before I got elected to office. And so when I look at the standard in the bill, it's not clear to me that standard necessarily makes it clear that writing a check for $100 to go to the Fairfax County Democratic Committee annual dinner to eat dinner.
Those are a question in there.
Yeah, I mean, how does that I mean, how does that, for example, that example square with this bill?
So, Mr. Chairman, members of the committee, the reason we picked the standard for the irrespective test is it's actually the standard that they use at the Federal Elections Commission. So there's a huge body of law on this already, and there's guidance that's been used to determine these things. So on the meals question, for instance, there's clearly a body of decisions that says you can use campaign funds to pay for meals during, for example, face-to-face fundraising events, right? So the question, there are answers to these questions out there. So the irrespective test is not, this is not a brand new concept that we've got to figure out without any context behind it. I think to some degree, right, using party events, I think it's a pretty easy answer. That you're there because if you're invited as a member of the delegation, right, and that's why I'm attending, and I'm advertised as a guest. I think it's pretty easy to make the case that it exists for two reasons. One, as an office holder, or two, as a candidate for office. Both of those would be allowed purposes under the bill. And again, and believe me, I understand it and take Senator McDougal and Senator Servo as excellent, much better than me lawyers, concerns very seriously about getting the words right. But again, you could write a bill that would be 60 pages long and you wouldn't account for every what if or hypothetical, which is why we try and use words that have been litigated, that have a history, that have some decisions behind them already as the standard, and then leave it to the regulatory, to the executive and the Board of Elections and others, the Attorney General, to help us fill in those details. And again, I think you'd be able to get some clear guidance that would be a hold harmless for you, right? If you say, look, I relied on directions that I received or regulations published by the state board, these frequently asked questions. I think the party dinner, for instance, would come up as probably an FAQ, since that's something we all have to deal with. And you could point right to that guidance to say, this is why I thought it was okay to put that on my report.
Thank you, Mr. Chairman. I see our resident election lawyer is next in the queue. I'll leave it to her to ask some questions.
Senator Vogel.
Thank you, Mr. Chair. I just wanted to say to Delegate Simon, when I saw this bill on the docket today, he had my greatest sympathy because I actually patroned this bill myself. Because as somebody who does practice in this area, this is a subject matter that gives both ethics lawyers and candidates and anybody in the regulated community an enormous amount of heartburn, and these questions are important questions to ask. And for the reason that the patron raised, the notion that the Federal Election Commission actually had to do a rulemaking and address this very specific issue of childcare explains why this is such an important question. Because once you do venture into this area, then you are subject to a high degree of scrutiny. So the language matters here. And so while I'm very supportive of the ethics around elections, people give us money because they have a high expectation that money will be used for election purposes and for election purposes only. And I believe that the spirit of this is absolutely something that we should support. But I do think that the language is important to get right. And so the fact that we're asking the questions we're asking is important. And yes, the language that he references is lifted from it is language that is recognized and reproduced in many states and then taken from the federal regulations. But I just want to say that people's questions are legitimate, and as this maybe makes its way through, it might be worthwhile to look more closely at the language. Thank you, Mr. Chairman.
Thank you, Senator Vogel. Are there other questions for Delegate Simon? Are there those in the public who would like to speak? And we're going to limit to 4 minutes aside.
If you would like to speak in support of the bill, please use the Zoom raise your hand feature.
So I would just please ask you to be cognizant of the fact that there may be people behind you in line who will want to speak too.
We have Michael Deal. Please go ahead.
Okay, Mr. Beal.
Please unmute yourself.
You are muted, Mr. Deal. You're muted.
Sorry.
Thank you, Mr. Chairman and members of the committee. I'm a volunteer with the Virginia chapter of American Promise, and we strongly support this bill. Nearly all states and the federal government ban the personal use of campaign funds. Virginia's reputation is at stake here. Legislators shouldn't be able to spend their campaign contributions on vacations, school tuition, mortgages, haircuts, nor investments. Virginians have the right to be assured by statute that their elected officials are good stewards of their treasure and their trust. Even if not a single legislator has to change their behavior as a result of passage, Virginians will have more reason to trust the system and their legislators. Voting yes on this bill is the right thing to do. Thank you very much.
Thank you very much. Who's next?
Josh McCrane, please go ahead.
Mr. McCrane.
Yeah, hi, my name is Josh McCrane. I'm a PhD in political science. I currently work at the Institute for Public Policy and Social Research, but I'm just speaking on my own and not representative of my employer. I think this is I'm an expert in campaign finance. I've published academic articles on campaign finance. I think this bill is common sense. It does exactly what the FEC has done for years. Literally verbatim what the FEC does. The FEC has a list of guidelines on their website about, for example, automatic exemptions to this bill. There's a lot of precedent for this. And I think importantly, it does establish trust in the integrity of the election process, even if substantively it doesn't change much in day-to-day elections. It's important for people to understand that the candidates are using this money appropriately. And so I do support this bill.
Okay, thank you very much. Who's next?
If anyone else would like to speak in support, please raise your hand. Lisa Coteen-Gerchik, please go ahead.
Thank you, Mr. Chair. Lisa Coteen-Gerchik for the League of Women Voters. We fully support this bill, and we would like to focus on the child care expense exemption. We believe that this rule would encourage a greater diversity of Virginia candidates, particularly women, who with younger children otherwise would not have an opportunity to run for elected office. Okay. Thank you.
Thank you very much. Who's next?
Ms. Shirley, please go ahead.
Hi, am I off mute? Hi, everyone. I'm Luba Gretchen Shirley. I'm the founder and CEO of the Vote Mama Foundation. We strongly support this bill. When I ran for Congress, my children were 1 and 3 years old, and very reminiscent of running for Congress. My baby in the other room just woke up as I was about to speak, and I handed him off to my husband. But I had my kids with me every day on the campaign trail. My mom was a teacher. She'd come home at 3:30 and she would watch them. But I was literally giving speeches and talking to constituents with a baby on my hip and a toddler by my side for 6 months of my campaign. And I put a request into the Federal Election Commission in 2018. And I said, can I use some of my campaign funds for childcare? And to my surprise, they said yes. And it changed the way that people run for office. We have now seen since 2018, 51 federal candidates use their campaign funds for childcare, both moms and dads, Democrats and Republicans. And in the state of Virginia, only 10% of your state legislature are actually moms with young children. There are so many institutional barriers that hold us back from running for office. The first step to empowering a diverse pipeline of working moms to step up and run and win is to ensure that no candidate has to consider the cost of childcare when weighing the decision to run for office. By making this one simple structural change, you have the opportunity to change your political landscape. We fully support this bill.
Thank you very much. Who's next? We only have 30 seconds left.
Lisa Sales, please go ahead.
Hi, Mr. Chair, members of the committee. I'm Lisa Sales with the Virginia Money Out Group and American Promise. This is an equity issue. Campaign finance is desperately needed in Virginia. Otherwise, we will have pay-to-play politics. We're also dealing with roadblocks put up to we the people, creating barriers to entry for women and Black and brown folks, which is why we're not truly representative here, nor in the halls of Congress. That's why I'm glad to see Delegate Simon's bill introduced with the child care provision. While this is only the beginning, a down payment on the types of more serious reform we need to see, I'm glad to see it happen. It's one step in the right direction, the moral direction, and it's better than no step. So really support this bill. Thank you.
Thank you very much. If there's anybody else in favor, just identify yourself and your group, and that's it.
Those are all our speakers, Mr.
Okay,
Chair.
are there people opposed?
If you would like to speak against the bill, please raise your hand.
Okay, the bill is before the committee.
Move the report, Mr. Chairman.
Got a motion?
Second.
And a second to report the bill. Are there additional motions? Is there further discussion? If not, please open the roll. Is that somebody that wanted to speak?
Yes, sir.
Strike the roll. Senator Surville needs to speak.
Thank you, Mr. Chairman. I'm sorry. We were in the corner having a...
You were talking. You weren't paying attention.
We were paying attention,
That's
Mr.
what
Chairman.
happens in class when you don't pay attention.
Now, Mr. Chairman, we were paying attention. We were talking about what to do on this motion. Mr. Chairman, I want to say that I think there's a general consensus on child care, and that ought to be something that ought to help, that ought to be something that could be funded with contributions. I think there's a lot of, I'll just say, caution about the vagueness of the other words without the regulations and the guidance being published. So I think you're going to see a lot of us vote to support this, but I would not be surprised if there's some sort of substitute on the floor to provide us a chance to weigh in once we get a little more clarity about exactly what the State Board of Elections means on its regulations. And I just wanted to say that so nobody was surprised.
Okay, are there additional speeches?
Again, move to report, Mr. Chairman.
Again, second.
A motion and a second. Please open the roll.
Ayes 11, noes 2, two abstentions.
Okay, your bill reports. Congratulations, Delegate Salmon. Delegate Bagby's got the next bill. The next block of bills, and we only have 6 bills left. The last bill, the first 5 bills left the House on partisan votes for the most part. Not always partisan, but close to partisan. The last bill only had a few votes against it. So, House Bill 1968 from Delegate Bagby, are you there?
I'm here.
Okay, tell us about your bill.
Thank you, Mr. Chair, members of the committee. House Bill 1968 permits the electoral board or general registrar of a county or city to provide absentee voting in person in the office of the general registrar or voter satellite office on Sundays. So it allows for Sunday voting.
So that's the meat of the bill. It simply expands absentee and person voting to be able to occur on Sundays.
Correct.
And you leave it up to the local registrar. Is that correct?
Correct. It is not a mandate.
Okay. Are there questions of Delegate Bagby? Are there those in the public who would like to speak?
If you would like to speak in support of the bill, please raise your hand. I see Clara Wheeler, Mr. Chair.
Does she want to speak in favor or against?
I believe in favor.
Okay. And Delegate Peake, Senator Peake, do you want to speak first, or? Okay, you have a question? Do you want to speak? Do you want a question of the patron? Senator Peake has got a question for you, Delegate Bagby.
Sounds like fun.
Yes, Delegate Bagby, or it may be legal. Is it constitutional that we would have different amounts of voting days in different jurisdictions? Has that been looked into, Delegate?
I'm not sure that it's been looked into, but it does occur.
Mr. Chair.
Senator McClellan.
Currently, not all localities have Saturday voting on every day, in the entire 45-day window. Every locality has Saturday voting in the last 2 weeks, but we leave it to the localities to decide if they're going to do Saturday voting within the other weeks of the 45-day. So that is already something that occurs now.
Even Senator Peake, out in the part of the state where I live, registrars do things a little bit differently depending on the locality.
All right, thank you. That answers my question.
Okay. Delegate Bagby.
Yeah, Mr. Chair, real quickly, and one of the reasons why we wanted to bring a bill like this forward is because even as we looked at Saturdays this last go around, there were a number of localities that had Saturdays for all of their locations where they had satellite voting or voting set up, and there were some that just had one location. And as the senator just mentioned, there were some locations that didn't have any Saturdays. But again, it's up to the locality.
Okay. Are there those in the public who would like to speak to this bill?
Clara Wheeler.
Dr. Wheeler.
Yes, sir, Mr. Chairman. Thank you very much for this ability to bill. This is, I realize, an option
but as we all know, pressure can be brought to bear. I'm speaking not as a registrar, but as someone who supports the registrars who are extraordinarily overworked. They need a day of rest. And if you put pressure on them to be open on Sunday, they will comply and they will be open. I would ask you not to put this pressure on them.
So you aren't in favor of this bill?
I am opposed to this bill.
Okay, thank you, ma'am. Are there others who would like to speak to the bill?
Galen Kenoyton.
Yes, ma'am, Gayleen.
Yes, good afternoon. My name is Galen Kenoyton. I am with the Virginia State Conference NAACP, and we are fully in support of this bill. Fully in support of this bill. We already do souls to the polls as is, so we really want to have souls to the polls. Thank you.
Thank you. Are there others?
Yes, Mr. Chair, we have Allison Robbins.
Ms. Robbins.
Thank you, Mr. Chairman. Allison Robbins, President of the Voter Registrars Association. We have concerns about House Bill 1968, and our concern just relates to the potential for voter confusion if some localities locally offer Sunday voting while other localities don't. We're just concerned that it's going to create some confusion. Thank you, Mr. Chairman.
Mr. Chairman, can I ask the witness a question?
Senator Eben, you can. Don't badger her, please.
I won't badger her. I just wanted to ask, what do you do if there's confusion about differing hours on Saturdays in different localities? Is that been a serious problem?
We recognize that's also a similar issue. We have those same concerns about the differing of voting hours and the differing of offering additional Saturdays. As an association, we would support a more uniform application of early voting hours and early voting days in the state.
So is that a request for an amendment to this bill that we require all registrars to be open on Sundays?
Now you're back, Mr. Chair.
I apologize.
Thank you, Mr. Chairman. Not necessarily at this time, no.
Are there others who would like to speak to this bill?
I see no more hands, Mr. Chair.
Okay, the bill is before the committee. I think we understand it.
Move to report.
Got a motion and a second. Are there further motions? Is there further discussion? If not, please open the roll.
Ayes 10, noes 2, 3 abstentions.
Okay. The bill is reported. Congratulations, Delegate Bagby. Delegate Helmer has a House Bill 2020, and it's similar to a bill that we have seen in the recent past. Delegate Helmer, are you out there?
I am, Mr. Chair. Are you able to hear me, sir?
We can hear you. Yes, sir.
Thank you, Mr. Chair. I believe the clerk may have a line amendment, Mr. Chair.
Okay.
I'm going to read that in.
Brooks has the line amendment. Is that correct?
Mr. Chairman, can you hear me?
Right here, yes.
Okay. 1 second.
Okay, you faded out on me there, Brooks.
Can you hear me now?
I can hear you now, yes.
Okay, sorry. Yeah, Mr. Chairman, the line amendment is on line 19 of the engrossed bill after who are insert otherwise eligible to participate in the nominating process under that party's rules, but are.
Okay. Do you understand the amendment?
Mr.
Got a motion?
I don't understand that. Please explain.
Okay, what he's saying, it's on line 19, before unable. Your voters who are otherwise eligible to participate according to the party's rules. It allows the party to make the rules about who is eligible or not eligible.
Mr. Chairman, I think the example would be that some parties might say if you voted in the nomination process of another party within the last 5 years, you're not eligible to vote in that party's nomination process.
Thank you.
And so that would make it clear that you could still exclude people who voted in another party's nomination process from yours.
That is a good example. Okay, we've got a motion.
Pretty good lawyer.
I try. Thank you.
Do we have a second on that amendment?
Second.
Okay, got a motion and a second on the amendment. All in favor, say aye. Okay, the motion is the bill's amended. Delegate Helmer, this bill is close to a bill that Senator the staff had in 2018 that passed this committee and died on the floor of the Senate. In those days, it was a bill that the Republicans were for, the Democrats were against, but now I think the Democrats are for it. Is that right?
That's right, Mr. Chair. Would it be all right if I spoke a little bit to the bill and talk a little bit about some changes we made?
Absolutely.
All right, Mr. Chair, members of the committee, I appreciate your indulgence as there's a lot to this one. This is a bill that ensures that party nominating processes which are recognized by the Commonwealth are accessible to troops, students, people with disabilities, and individuals who might pose a public health threat. Critically, it allows parties to choose any method of nomination in accordance with their bylaws, but it requires that they make that method of nomination accessible. Both major parties have allowed, and this is a change from 2018, both major parties have allowed for virtual participation with caucuses or conventions in Iowa and New Mexico. Republicans have done it in Kentucky. In Virginia, the past year, the Fairfax County Democrats held a virtual caucus for its endorsement process for the town of Vienna, which also allowed for mail-in voting. We expect with the pandemic, these options to continue to grow. On its face, the bill ensures that a soldier serving in Afghanistan and the other 90,000 Virginians serving on active duty aren't deprived of their ability to participate in selecting their nominee, so long as the service member meets the other requirements of their party to participate in the nominating process. Same is true for the 150,000 Virginia students in higher education, the million Virginians with disabilities. And, there are also specific concerns that were raised in the past, and just wanted to talk real quickly about how both this bill and the amendment in front of you address them. The first one is this bill does not change in any way Virginia's stance on electronic voting in a state-run nominating process, so no change there. It also exempts special elections in those situations in which a candidate dies or the party does not otherwise have a nominee. In those situations, it might be very difficult, as the body has raised in the past, to actually do a inclusive nominating process, and this bill exempts them. Lastly, the bill isn't intended to require a political party to include voters who are currently ineligible to participate under party rules. And that was described before, but that's what that amendment does. It just really clarifies that when we say eligible voters, we mean eligible voters who are eligible to participate in that party's nominating process. Mr. Chair, members of the committee, that's the bill, and happy to answer your question.
It seems to me, that in 2018, part of the discussion was we didn't think the state ought to be telling the parties how to run their affairs, but your amendment took care of that issue to a large extent. The parties are still in charge of deciding who participates, but
Mr. Chairman, with that, I move the report.
Okay, we've got a motion and a second to report. First, let's see if there's anybody in the public who needs to speak to this bill.
If you would like to speak in support of the bill, please raise your hand. Julia Billingsley, please go ahead.
Julia Billingsley.
Mr. Chairman, good afternoon. I'm Julia Billingsley with Virginia 21. We strongly support this legislation and appreciate the patron for bringing it forward. Thank you.
Okay, thank you, Julia.
Matthew Scoble, please go ahead.
Scogle.
Mr. Chair, members of the committee, Matt Scoble with Unite America. We are in support of this bill. Thank you.
Thank you very much, Mr. Scoble.
I see no more speakers in support, Mr. Chair.
Are there speakers opposed?
If you would like to speak against the bill, please raise your hand.
Okay, we've got a motion and a second to report the bill. Are there further motions or further discussion? If not, please open the roll.
Ayes 10, no 1, 4 abstentions.
Thank you very much, Delegate Helmer, and congratulations. Your bill report.
Thank you, Mr. Chair.
Delegate Levine has House Bill 2082.
Thank you, Mr. Chairman and members of the committee. House Bill 2082 adds transparency to the redistricting process. It requires meetings and hearings of the Virginia Redistricting Commission to be live streamed, whether held virtually or in person, and to allow for public comment. Meetings and hearings can be held virtually, but if they're held in person, they're required to be held in different regions of the Commonwealth. An additional public hearing is required in the event that the General Assembly rejects the initial maps. And the public gets to know where the maps are because any adjustments made are made on the website. So the public is abreast of everything that's going on. The bill also requires that in the event the Supreme Court of Virginia is called upon as a backstop that their meetings and hearings are also open to the public. And the reason for that, frankly, is that it's quite easy to send this to the Supreme Court. Only 2 delegates or 2 senators can do so. 2 can actually overrule 14 on the commission. And so the thought is that if we require the Supreme Court of Virginia to, when acting as a backstop commission, to have the same restrictions the commission has, it's less likely people will play games with it. So the commission does not allow ex-parte communications, does not allow you to secretly meet with someone and draw the maps. This would prevent the Supreme Court from doing that as well. It says all meetings are public, Supreme Court meetings are public as well. Now, under current law, there is a Democratic and Republican special master appointed if the backstop of the Supreme Court is used. And those special masters could meet in private and help draw the maps. They'd have to. They don't work a lot of time together. But the idea is, like with the commission, that the Supreme Court relies on their joint work that comes out, and they may have several maps. The Supreme Court still establishes a district, but each of these districts are approved by both sides to ensure a fair process. And my hope is that with a very fair process before the Supreme Court, it'll never be used. That if we see that the Supreme Court is fair with all the restrictions the commission has, folks will say, well, we don't need this backstop. We'll just use our original commission. So with that, Mr. Chairman, members of the committee, I'm happy to answer any questions.
Are there questions for Delegate Levine?
Yeah, Mr. Chair.
Senator Eben.
I'm concerned on lines 87 through 90 about all communications being in a public hearing. Does this mean that the special masters can't contact a local electoral board about precinct lines or about the number of people that are registered outside of a public hearing?
So it says, and this, by the way, is the exact same language that's used for the commission. It copies that language. It says the court, the special masters, and DLS, and any advisor or consultant shall not communicate with any other persons about matters relating to the establishment of districts. So the way I read this, and again, if you have an amendment to make it better, is that Division of Legislative Services could certainly, any other shall not communicate. I guess they would have to have a public meeting or hearing. I would say this, though, the commission also has to have a public meeting or hearing. That's current law. So I simply copied the language from the current law for the commission. So again, if you'd want them to be able to contact a registrar, I would certainly be happy to have that as an exception.
Senator Eben, did that answer your question?
I think so.
Okay, are there additional questions? Are there those in the public who want to speak to this bill?
Mr. Chairman, if I could ask a quick question.
Senator Bell's got a question. I apologize. Senator Bell. Delegate Levine, you still there?
I'm still here.
Thank you, Mr. Chairman. Delegate Levine, I know you spoke with me about this, but question that came into my mind, does this add to the timeline of what you're doing with the advertisements, public notices, and the other recording issues?
I don't think it adds much. The live stream happens anyway. It doesn't add any additional public meetings except one, and that is if it's rejected. It does add one public meeting if it's rejected. Otherwise, the timelines are the same.
Delegate Senator Bell, did that answer your question?
Thank you, Mr. Chairman.
Yeah, are there additional questions of Delegate Levine? Are there those in the public who would like to speak?
Yes, Mr. Chair. We have
a bunch?
I'm sorry, Mr. Chair.
Do we have a bunch?
I see 4 hands.
Okay, 4 hands.
Yeah. Aaron Corbett, please go ahead.
Thank you, Mr. Chairman and members of the committee. My name is Erin Corbett, and I am the redistricting coordinator for the Virginia Civic Engagement Table. We believe the newly developed redistricting commission should work to be accessible and transparent in all of its meetings, decisions, and communications. By codifying language access and meeting transparency, House Bill 2082 helps ensure this. On behalf of VSET, we ask the committee to vote in support of this legislation.
Okay,
thank you.
Thank you very much. Who's next?
Marianne Burke, please go ahead.
Ms. Burke?
Yes, thank you. I'm Marianne Burke from the Virginia Grassroots Coalition. I ask that you please vote for this bill. A goal of Amendment 1 was to create a system that was transparent to voters and watchdogs. This bill will bolster the transparency of the Redistricting Commission, prohibit off-the-record negotiations, and ensure that Virginians have adequate opportunities to attend hearings on how the maps were drawn. This legislation will not hurt or delay the Commission's work in any way, but instead it will help make better maps for Virginia. So I hope to see that you can report this bill.
Okay, thank you very much. I understand a few more people have raised their hands, so I'd ask you to limit your comments to 30 seconds each.
Mr. Chair, we're having technical difficulties. It'll just be a minute.
I'm not, did you just call Megan Ryan? Megan Ryan with the Virginia Coalition for Open Government. We advocate on behalf of everyday citizens who want to hold their government accountable, and we support this bill.
Okay, thank you very much. Who's next?
I could go next. The Virginia State Conference, NAACP, supports this bill for transparency and public trust. I think it'll help with public trust, but I do think that Senator Evans' comments should be taken into consideration.
Thank you very much, Ms. Quinnoy. Who's next?
Lisa Stabe, please go ahead.
Yes, ma'am.
Lisa Stabe, please go ahead.
Lisa Stabe, Virginia Education Association. We're in support of this bill. Thank you.
Okay, thank you very much. Are there others?
Yes, Mr. Chair. We have Edward Macon. Please go ahead.
I think he's from the Supreme Court, and he's probably got some views, but he's probably just here to answer questions. Is that correct?
Yeah, that is, I'm happy to answer questions. We do not have a position on the bill. We had two concerns based on our staff review that potentially raise constitutional questions.
Well,
One,
I was wondering, I was going to ask you, Mr. Macon, on line 59, all meetings and hearings of the court regarding the establishment of districts shall be open to the public. I mean, does the legislature tell the court how to hold meetings otherwise?
Mr. Chairman, I think that does raise a separation of powers issues. As you know, courts have oral hearings, they have oral argument in the case of the Supreme Court, and then the decision is made, it's published in writing for everybody to see, but the deliberations of the court are never open to the public. And so that's the concern with that provision.
Well, my other question was on line 69. It says, any plan submitted to the court shall be affirmed by both special masters to be a product of their cooperation and their collaboration, and only a plan so affirmed may be adopted by the court. Doesn't that language undermine the constitutional amendment altogether?
I thought, Mr. Chairman, I think it might. The constitutional amendment says in 3 different places, if this comes to the court, and I would hope it doesn't get that far, but if it does, then the districts would be established by the court. I would just note one other, the existing law, which you see at subsection F of 30-399, says the court appoints 2 special masters to assist the court in the establishment of districts. As I read the new language at line 69 to 71, that would have the court assisting the special masters, or the court would veto or could only accept or veto whatever the special masters come up with. So we did have a question about that. But those are the only concerns.
Those are the concerns I flagged when I read the bill.
Mr. Chairman?
Senator Spruill.
You asked those questions, but was there a concern that he had? You asked the question yourself, but okay, are they the same questions that you had?
Yeah.
Okay, thank you.
But just from the Supreme Court, he was just there. If anybody else has questions, you ought to ask them.
Thank you.
Okay, is there anybody else in the public who needs to speak?
Yes, Mr. Chair, we have Joanne Collins, and just a reminder, if you'd like to speak, to please raise your hand.
Ms. Collins?
Good afternoon. My name is Joanne Collins. I'm with Herndon, Reston, and Indivisible, and we are in support of this bill.
Okay, thank you. Thank you very much.
Mr. Chair, our final speaker is Mary Detweiler.
Ms. Detweiler.
Yes, hello. Can you hear me?
Yes, ma'am.
Hi, I'm Mary Detweiler. I'm a resident of Arlington, Virginia, and I am strongly in favor of this bill. I believe that now, during the time when there is so much distrust nationwide and in Virginia about our election institutions, this bill could not be more timely. So I strongly oppose it and hope the committee will pass it. Thank you.
Okay, thank you very much, ma'am.
Mr. Chair,
Senator McClellan.
I have a question that I'm not sure if it's for the patron or for Legislative Services Council.
Brooks is on the line, so Brooks, pay attention. Senator McClellan's got a question you or Delegate Levine might have the answer to.
So as I read lines 87 to 90, Section H, dealing with prohibiting the court, the special master, and any DLS staff, et cetera, to talk to anyone about matters related to the establishments and districts. If the legislative districts end up challenged in federal court under the Voting Rights Act, which, as we all know, has happened before, as I read this section, it would prohibit any of these entities or individuals from talking with, either leading up to or as a part of that case, any lawyers to determine, whether they're in discovery or anything around that case. And I guess this is for Brooks. Is that an accurate reading of those lines, and can we do that?
Mr. Chairman, Senator McClellan, that's a potential reading of that. I would agree. It is related to wording related to the establishment of districts pursuant to this section. How one interprets that is that you can't talk about the establishment of districts insofar as they're about that content, or is it you can't talk about districts just in that context, if that makes sense, that distinction. So, that would be the decision a court would be making if this came up. And
Mr. Chairman, I think I can respond a bit further, if I may.
You sure may.
Thank you, Mr. Chairman. Lines 87 to 90 are a direct copy of current law, which is section 3392G. And this part isn't changed by my bill. But 3392G says, this is a direct quote, commissioners, staff of the commission, and any other advisor or consultant to the commission shall not communicate with any person outside the commission about matters related to reapportionment or redistricting outside of a public meeting or hearing. So that's current law. And if that's a flaw, and it may well be a flaw that Senator McClellan has exposed, that's a flaw of current law as well. What I've done in merely copying that language is said the same language that applies to the commission also applies to the Supreme Court. That being said, I'd be happy to make clear, I read it as in the establishment of districts, meaning while they're establishing the districts, they can't communicate. But a court hearing happens long after the establishment of the districts. It's about ruling on whether the districts are good or not. They're not actually establishing it while there is a court hearing later on about whether they're fair or not. So my reading of it was, no, it's only the establishment. But again, I copied it from 3392G, which is unchanged. And actually, that's my same response to Senator Eben, that it's exactly that same language. And maybe if it needs to be tightened up, I take it by, we could get an amendment to tighten it up to make clear, because certainly my intent was only during the establishment of the districts. And frankly, we could tighten up current law too, because even if this bill dies, we still have the same exact language problem in current law 3392G with respect to the commission.
Senator McClellan, did that answer your question?
It does, Mr. Chair, and I think it is worth making that clarification in both current law and in the new section, because as someone who was deposed and ended up being a witness in 2 federal court trials on the redistricting cases, I think that's why that jumped out at me, and I don't remember being present for the hearing on the current law, or I would have mentioned it then.
Okay, Senator Sproul.
Mr. Chairman, 2 things. The first one, that I got my new hearing aid in, and someone north on that side of the aisle, they could kind of chill a little bit so I could hear they're talking too loud on that side of the aisle.
Okay, you hear that?
They're both Democrats and Republicans.
Calm down over there.
Okay. Thank you, Mr. Chairman. The next question, Mr. Chairman, my concern was the gentleman from the Supreme Court, I might be saying it wrong. Yes, how are we going to fix those two? I'm supporting the bill, but I want to know how can we fix those two concerns that he has.
I think
May I address that, Mr. Chairman?
you can or I can. I mean, we probably have different answers.
We may well have different answers. You want to go first, and I'll go second?
I would have heard the chairman.
I think that the problems identified by the Supreme Court are fatal to this bill.
All right.
I mean, honestly, but Delegate Levine probably has a different view.
I do have a different view. So, Mr. Chairman, in hundreds of years of Virginia history, the Supreme Court has only acted heretofore as a court under Article 6 of the Constitution, hearing judicial matters with a plaintiff and a defendant, in re, with papers, briefs, all of that. And none of that is disturbed by this. In this, and the only time in the whole Constitution of Virginia, the Supreme Court is not acting under the judiciary branch, Article 6. It's actually acting under Article 2. And it says basically the Supreme Court is a backup commission. There's this commission, and if two people of the commission don't want it, the Supreme Court's the backup commission. They are establishing the districts. They are acting as politically as the commission is. And that's a new role for the Supreme Court, frankly, and maybe one they didn't welcome, but it's in our Constitution, and that's where we are. So it strikes me that saying that when the Supreme Court is acting in its capacity as a commission, not acting as a court, not if it's ruling on the law, it could still do its deliberations. But when it's politically choosing among maps, then it's exactly doing the exact same content the commission is doing. And in that narrow capacity, it should be open to the public. And it's not a separation of powers issues because the Supreme Court is acting as a commission, not acting as a court.
Thank you,
and
sir.
That's why I think it's actually perfectly constitutional.
Senator Evans got something.
Yeah, I just wanted to ask, the bill seems a little bit prescriptive in that it's requiring certain numbers of hearings to be held by the commission before they finalize their plans, 3 public hearings in one case or 1 hearing for if they had to redo the plan. And it says shall hold at least 3 public hearings in one portion, but then it says meetings and hearings that are held in person shall be conducted in different regions of the Commonwealth, including the Northern Virginia region, the Central Virginia region, the Hampton Roads region, the Southside region, and the Southwest region. So when you say they have to hold 3 public hearings, but they have to hold them, do they have to hold them in all 5 regions?
No, the way I see it, Senator Evan, is that first of all, they can have them all virtually. But to the extent that they're held in person, there shouldn't be 2 in the same region.
So they can't hold 2 in Richmond. You want to specify that?
Well, they could, I guess, if they went to all 5 and had 6 of them, they could. But the 3 public hearings are part of the constitutional amendment. That's actually not anything I've added. The only thing I've added is the 1 public hearing if it's rejected.
There's new language on line 28 that says shall hold at least 3 public hearings in order to receive and consider comments from the public after prior to voting.
Right. That's if you look at the original language, that's in C 21 to 24.
Okay. Delegate Levine, I'm correct that these sections you're amending have just been the law since November of this past year.
That's correct.
Okay. So, okay. Are there additional questions from the committee? Are there additional people that from the public who need to speak? We've already heard everybody?
Yes, Mr. Chair.
Okay.
Last thing I'd say, Mr. Chairman, is if Senator McClellan would like me to try to fix her section and work with her on it, I'd be more than happy to take it by and work on that and really tighten up both the bill and
Delegate Levine,
don't do that.
This is the last meeting. This is the only meeting we're going to have. So what I'd suggest,
I could do it as a floor amendment.
Yes, if the bill gets out of committee, then get a floor amendment prepared to resolve Senator McClellan's issue.
Be happy to.
Move the report, Mr. Chairman.
Okay, we've got a motion to report. Is there a second? Got a motion and a second to report. Are there further motions or additional discussion?
Mr. Chairman, reluctantly,
Senator Bell.
Mr. Chairman, move to PBI. I think there's issues with the bill. I appreciate the patrons' hard work on this, but given the fact that we just passed the other law, the Supreme Court and other answers or other information on this, I think that this is not the time for these changes.
Okay, got a substitute motion to PBI. Is there a second? Got a substitute motion and a set to PBI that's been seconded. That's the motion we'll take up first. I'd ask the clerk to open the roll.
Senator Howe to abstain. Senator Howe, let me get the 861 will make it 762.
Thank you, Delegate Levine. The next bill is Delegate Lopez. It's House Bill 2125. It's a bill that allows for pre-registration of certain voters. Delegate Lopez, are you out there?
Right here, sir.
Okay.
Hello, Mr. Chairman, members of the committee.
Well, if you want to tell us about your bill, you'd be welcome to.
Thank you, Mr. Chairman. Mr. Chairman, members of the committee, HB 2125 would allow individuals who are 16 years of age or older and otherwise qualified to vote to pre-register to vote. Pre-registration allows Americans who are not old enough to vote to complete a registration form and be automatically added to the voter rolls when they reach voting age. Similar to other states, Virginia allows residents to register before they turn 18 if their 18th birthday is on or before the next election. Pre-registration allows young people to complete a registration form outside of that window. Currently, pre-registration has been enacted in 18 states, including Colorado, New York, Washington, Louisiana. As a result of expanded access to the ballot box that the General Assembly enacted last year, Virginia was a national leader in youth voter turnout in the 2020 election. 20% of all Virginia's voters were aged 18 to 29, a record only Georgia could match. Americans' interest in elections increases as election day approaches, which creates a problem disproportionately affecting younger Americans. Unlike many older voters who registered in a previous election and don't have to re-register, young people are often first-time voters. Far too often, newly eligible voters don't think or know about the need to register until just before Election Day, which in many cases is after Virginia's registration deadline is already passed. Pre-registration creates many more contact points at which government agencies, teachers, or third-party voter registration organizations can offer young people registration opportunities. Bringing young people into the voting system even before they reach voting age has important benefits. It makes it easier to vote, it increases democratic participation, and when young people are empowered with the information they need to register, they show up. In addition, a young person's willingness to vote in a given election is one of the best predictors of whether or not they're going to follow up the next election. So simply put, helping young people pre-register to vote increases the odds that they'll make a lifelong habit of voting and civic engagement.
Okay,
I'm proud, Mr. Chairman, members of the committee, that this bill was supported and lobbied by both the Virginia teen Democrats and the Virginia teen Republicans. I hope it's the will of the committee to report HB 2125. Thank you, Mr. Chairman.
This would allow a 16-year-old to pre-register. Once they turn 18, they would roll over to the registration file. It wouldn't allow anybody to vote before they're properly registered, though. Is that correct?
That's correct, Mr. Chairman. It's simply a process that, and part of a line amendment I put on the House side would actually what we did was we made a small change that the provisions of this act shall become effective on October 1st, 2022, which means that by doing this, it's in line with the overhaul of the VERA system, and that so all of the provisions can be built into the new system as opposed to having any kind of a need for an appropriations request for this bill. And so everything gets loaded into when we do the overhaul of VERAs.
Okay, thank you, Delegate Lopez. Are there questions for the delegate? Are there those in the public who would like to speak to this bill?
If you would like to speak to the bill, please raise your hand. We have Lisa Coteen-Gerchik.
Okay, Ms. Coteen-Gerchik.
Thank you, Mr. Chairman. I'm Lisa Coteen-Gerchik from the League of Women Voters of Virginia. We solidly support this bill. We urge you to vote for it. Thank you.
Thank you very much. Are there others?
I see no hands, Mr. Chair.
Okay, the bill is before the committee. It got out of the House on a 55, 40, 44 vote or something like that. Is that correct, Senator Lopez? 54.
It was similar to that, yes, sir.
Something like that, yeah.
He's not a senator yet, bless his heart. He's not a senator yet.
Yeah, that's right.
I don't want to take that step.
Okay, the bill's before the committee.
Move the report, Mr. Chairman.
Okay, got a motion and a second to report. Are there additional motions or further discussion? If not, please open the roll. Delegate Peak, a lot of red lights over there, man.
Ayes 11, noes 3.
Okay, congratulations, Delegate Lopez. Delegate Converse Fowler
Thank you,
now.
Mr. Chairman, members of the committee. Appreciate it.
House Bill 2198. And you're out there. I'd appreciate your telling us about your bill.
Thank you, Mr. Chairman. HB 2198 is an election bill that would close what most would consider a loophole that exists in election law. Right now, localities can choose between 3 city council representation options: at-large, districts, or a combination of at-large and districts. So Chesapeake has a fully at-large city council system where all the members can live anywhere they want and represent the entire city. Norfolk has a district system, which they have wards that the city council members have to live in and represent that district. Virginia Beach has a combination of districts and at-large representation, and some of the council members have to live in their districts and some are at large. These systems are unchanged with this bill. This bill addresses who is considered a qualified voter in each system that uses district representation. So right now there is no clarification who can vote for district representatives. This bill would clarify that a qualified voter in a district election would have to live in the district to vote for their district representative. It would not allow voters to vote for other district representatives. So if the seat is at large, then all the voters in the district can still vote for the at large. It doesn't change anything about that. What this bill does is bans the use of at-large voting in district systems. In essence, you have to live in the district to vote in that district. Right now, a locality can use district council seats and that are voted on by the majority of the city. The city at large would choose their representatives for them. This practice is a disenfranchisement to the voters of a district. Their voting power is diluted, and they do not have the power to elect a candidate of their choice. So this really comes down to whether or not the General Assembly wants to ensure that voters have a true say in who represents them, or if we want to allow a majority to choose for the minority. So this is a good bill, it's good policy, and our election systems need to work for the people. Thank you, Mr. Chair.
Thank you so much. An issue that was raised with me was that there's some litigation pending in Virginia Beach that this would undo. Do you know anything about that?
Mr. Chair, that would be a federal case that has nothing to do with this law and what we're doing. It has to do with the Voting Rights Act, and I believe there could always be a pending case. Is the way that it's been explained to me, is that there could always be a pending case going with an issue like this.
But this issue doesn't go to the crux of that case, does it?
No, Mr. Chairman, I checked into that, Mr. Chairman, before I got it because I heard that before. No, it does not.
Senator Spruill says it does.
And I asked lawyers because I'm not a lawyer, by the way.
Okay.
Mr. Chairman, that is not the
Senator Donovan.
Thank you, Mr. Chairman. That is not the information I have, is that the litigation is relevant to this piece of legislation, and I think that's a problem. And I have that from a lawyer.
Mr. Chair.
Senator McClellan.
Can someone tell us what the actual subject of that case is?
Is there anybody online who can tell us about the litigation in Virginia Beach?
If so, please raise your hand.
Mr. Chairman.
Senator Donovan.
I don't have the answer to that question, but I know that the city committee in Virginia Beach has a meeting today, which is why they were not available to be here to speak to this.
The city committee, you mean the city council? Or?
Council, yes, sir.
Okay.
Mr. Chairman, let me back it up.
Hold on. Let's see if Senator Donovan's done.
No, Mr. Chairman. I just wanted to mention that, yes.
Okay, Senator Spruill.
On that same, that's not so, Mr. Chairman. A member of the Virginia Beach City Council called me last night. He said on 8/20/20, the City Council vote 65, a vote not to let people to have input. So as far as that cop out, as far as they meeting tonight, This member says on 8, I guess that's August 2020, City Council vote 6-5 not to let people have input. Now, of course, they meet tonight, the same thing I had with my bill when I brought up. All of a sudden, these councilmen are saying, well, we have no input. We did not have had a chance to have a meeting. This member of council called me last night. Mr. Chairman, I will give you his name, but I won't announce it, but you can have it right here. Said they voted 6-5 not to have input by City Council. That was done on 8/2020.
I've never known you not to tell me something that wasn't right.
Mr. Chairman,
Senator Bell.
Could we have the patron address the issue about the lawsuit, or?
There's somebody on the line who I've been led to believe has some information about this, and it's Deborah Bryan. Let's her talk, and then if the patron has information about the bill, I'd be glad to hear from that too. Ms. Bryan, are you out there?
Please unmute yourself.
While we're waiting, I'm concerned.
Apologies, I was on mute. Good afternoon, Chairman Dietz and members of the committee. My name is Deborah Bryan, and I'm the Legislative Affairs Liaison with the City of Virginia Beach. I can tell you that House Bill 2198 directly impacts and unilaterally changes the way that the system that we vote in right now. And I understand what the delegate has said, and respectfully, in 2020, the Virginia Beach City Council did vote to reject a resolution for another referendum to determine the election system for Virginia Beach. And that is true. The reason they did that, though, when they was because, one, we were under multiple executive orders for the COVID pandemic, and two, at the time we were, and we still are, party to a lawsuit on this very issue, of which Delegate Converse-Fowler testified. This federal case is still pending, and we still have not gotten the ruling. And House Bill 2198 could specifically come out different than what this federal ruling is. So that's why the city is opposed to this. We would really rather that the federal law and the judge be able to give his rendering and his finding. And if at that time that is not what everyone feels is the correct thing, there are two other bills, House Bill 1890, which is in your committee today, and Senate Bill 1395, which already passed. And even though the city has some concerns over these bills, they do address the issues, and they do provide for a system where the voting can be changed. 2198.
If I could ask you just to tell us a little bit about the case. Who are the parties? Where is it pending? What are the issues that in dispute? I mean, how long has it been going on? When do you expect a resolution?
Okay, so the lawsuit was filed in 2017, and there are several plaintiffs who are alleging that this exactly the subject of this bill, that they would like the city to change the way that it votes. Delegate Converse-Fowler was a witness in the case, and did give testimony. And basically, the outcome of that lawsuit has the ability to change the way the city of Virginia Beach conducts its elections. Like I said, it was in 2017. It didn't wrap up until, I'm going to say, September of 2020. And we are currently right now awaiting the ruling from the Eastern District of Virginia in Norfolk.
Mr. Chair.
Mr. Chairman.
Mr. Chair.
Senator McClellan, then Senator Spruill.
Thank you, Mr. Chair. If the case in question is Holloway versus the city of Virginia Beach, ma'am, is that the lawsuit that you're talking about?
Yes. Yes, you are correct.
Okay, Mr. Chair, that lawsuit is on the question of whether Virginia Beach's current at-large voting system violates Section 2 of the Voting Rights Act. That is a different question from the question that is being addressed in this bill.
There you go.
This bill is addressing whether or not, and Delegate Converse-Fowler can correct me if I misstate what her bill does, but it says that if you have a district-based or ward-based residency requirement, The member elected from each district or ward is to be elected by the qualified voters of that district. That is not the question before the court in that lawsuit. The question before the lawsuit is whether the current at-large system that Virginia Beach has violates Section 2 of the Voting Rights Act.
Okay, Senator Sproul, then Senator McDougal, then Senator Surville.
Now, Mr. Chairman, since the senator says that, because the question was, you mean to tell me of all the lawyers that we got who represent the House, that I'm saying that how come a lawyer in the House, we use the same lawyers in the House and the Senate, how come they didn't catch this? Because I asked the same question, and those lawyers who represent us in the House on this same bill said it's different, number one. Number two, this is since 2017. Now, let me be me for a minute, and that's new about that part. If you are voting, do they have wards or precincts in Virginia Beach? What are they called, wards? Let's say if it wards. Let's say, Mr. Chairman, in your ward, that what happened was you have to live in the ward, I assume, and everybody, you have to live in those wards. Mr. Chairman, the way it is now, you can get every household in your ward vote for you to represent that ward. But because the whole city votes, you still cannot win. Even though every member in that ward, whether it's one or whether it's 20,000, I don't know, if every member of that ward said they want you to represent them in that ward, but the whole city cannot. Did you realize from doing that, what they're doing, Mr. Chairman, you have members on that council that's been there when I was on city council 34 years ago. 34 years you got members, and also, Mr. Chairman, they got folks who they want to get reelected, no disrespect to Republican friends of mine. They're moving, they're doing the same thing. Been on there 20 and 25 years on the city council. And I can give you those names, because one of them was on the council with me. I was on city council in 1988. Person's still there. So I'm saying, how is that fair, Mr. Chairman, if you live in that ward and you get all 20,000 votes, and yet the whole city can vote and know you can't represent that ward? That's not fair.
Senator McDougal, you've disappeared from the queue. Do you still want to? Okay, Senator Surville.
I disappeared too.
Okay.
Mr. Chairman.
Senator Donovan.
Thank you, Mr. Chairman. I'm just going to say, Delegate, what is the process for the city to change their elections themselves? Is there a process that is part of their organizing structure?
Mr. Chair, I would answer the senator by explaining that they don't have to change anything. When this bill goes into effect, they wouldn't have to change anything. It would be about the voting system and who votes. So the change would actually not even who votes would be an election issue and who is in what precinct. So this would not be an issue that would need to change anything about the system. They can keep their combination system of at-large and districts. It's just who votes in them.
If I can ask a question, is their current district system and voting system described in the city charter? And
Yes.
Would this bill override the city charter?
Yes.
Mr. Chair, yes, it would, just as the May election bill would also change many charters.
Mr. Chairman.
Senator Donovan?
So does the city have the power to change their charter themselves?
No, it has to come back here.
Okay. And my understanding is that the city has the ability to vote with a supermajority to make these changes. That's not accurate?
Not accurate. Okay. Unless it's provided for in the city charter. And maybe, Ms. Bryan, is there some kind of supermajority change that can occur pursuant to the city charter?
No, there is not. I also just wanted to state, and this is on behalf of our city attorney who's directly involved in this, or one of our city attorneys who's directly involved in the case. The plaintiff's requested relief is one where they specifically asked the court, and I'm quoting, to declare that the Virginia Beach at-large method of electing members of the city council violates Section 2 of the VRA. Number 2, it joins the defendants from administering any future elections in the city of Virginia Beach under the current at-large method. That is exactly what 2198 does, and I believe that it is misleading to say that House Bill 2198, if it passes, that the city wouldn't have to do anything and nothing would change, because it would change immediately.
Okay, thank you very much. Are there members of the public who would like to speak to this bill?
Yes, Mr. Chair.
How many people do we have?
I see 4, Mr. Chair.
Okay, if we're not, I'm not gonna, if many more hands go up, we'll have to impose time limits. I'd just ask you to keep your comments brief.
Our first speaker is Gary McCollum. Please go ahead.
Mr. Chair, members of the Senate, I am a member of the Virginia Beach Interdenominational Ministers Conference. I'm also a citizen of Virginia Beach, and we stand in support of this bill. 2 reasons. One, this bill puts an undue burden on anyone running for office, city council or school board, because they have to run in 100 plus precincts.
Now, this bill doesn't, you're just saying the current situation does.
The current situation does. The current situation, it's an undue burden, the current hybrid system. And secondly, and more importantly, and Senator Spruill alluded to this, what happens is in those districts, because you can win in a district but still lose the election, there's certain parts of the city that are ignored. I can talk about SeaTac. I can talk about Queen City. I can talk about J Gardens. These neighborhoods have been ignored by the city historically because of this system of hybrid voting. Thank you, Mr. Chairman.
Thank you, Mr. McCollum. Good to see you again. Who next?
Jean Hanowich, please go ahead.
Hanowich.
Good afternoon, Chair and honorable senators. I'm here today as a private citizen. I'm actually a citizen of the city of Chesapeake, and we currently have an at-large system. If we were ever to move to a ward system, I would not like the system that Virginia Beach has. This issue is not just for Virginia Beach, but for other localities. I think the current system in Virginia Beach is very confusing for voters. It lacks transparency, and it also has an issue of accountability to the voters in the districts. Thank you very much for your time.
Thank you, ma'am. Who's next?
Lindsay Nathaniel.
Ms. McDaniel.
Hello, and thank you for your time. I'm Lindsay Nathaniel, a 20-year resident of Virginia Beach, and here to speak in support of the bill. At-large voting only benefits incumbents, some of which have been in office for years. District voting will prevent the dilution of minority voters. It'll give real people a chance to run for office that want to see change in their community. And most importantly, it will allow voters to hold their representatives accountable. Thank you.
Thank you very much. Who's next?
Ken Stoll.
The stool.
Ken Stoll, please unmute yourself.
Mr. Stolle.
Stolle. Ken Stolle.
Yes, sir. How are you doing?
The High Sheriff.
Yeah, that's right. Mr. Chairman, thank you for listening to me. I just wanted to talk for a minute. This issue has been before Virginia Beach since I was in the General Assembly. And in fact, in 1994, there was a bill to do the same thing, and that was rejected by Clancy Holland and myself, and it failed in the Senate. It was before your time, but it failed in the Senate. There hadn't been a referendum on this bill. There's been no public input on this issue by referendum since 1995 or 1996. The legislation in '94 was amended to take and call for a referendum, and the referendum failed. And so I think that, you know, to suggest that this bill does not replace the authority of the court to decide it is misleading. I think the issue that's being drawn into court is the exact same issue that this committee is considering, whether you should go to a ward system or have at-large voting. I'd also point out that the reason most people support the at-large voting is because if they go to a ward system, they only get to vote for 4 council members. They get to vote for all the council members now. And there's only 11 council members, so they'd never be able to vote on a majority of council members. And so 6 members would determine the outcome of the issues before them, and they could never, in some cases, they'd never get an opportunity to vote for those 6 members. Now they get to vote for all those members. In addition to that, I think that the district requirements serve the public very well, and I don't think there's any need But finally, I'd say that this is clearly special legislation, and it changes the charter of Virginia Beach, and there's no effort to try and have a supermajority vote on this, and it supplants the decision that the federal courts might make. And so I hope it's not the pleasure of the committee to report this bill.
Okay, thank you, Sheriff Stolley. Are there others?
Yes, Mr. Chair, we have 2 remaining speakers.
Okay.
Jessica Ackerman, please go ahead.
Ms. Ackerman.
Good afternoon, Mr. Chair. Jess Ackerman with VML. We feel this is a local issue and would encourage the body to allow localities to find a solution here that best meets everyone's needs and interests. Thanks.
Thank you, ma'am.
David Washington, please go ahead.
Mr. Chair, my name is David Washington, and I'm speaking in support of House Bill 2198. I've worked in local politics for 10 years in Hampton Roads, 6 of those in Virginia Beach. And all I'm asking for this committee to consider is to allow the people that live in the district to have the final say on whether or not the individuals that represent them should be elected and represent them in their district. Let them be the only ones that are the ones that represent them on city council. The communities in Virginia Beach, for example, I call them boroughs. They're very different. Communities on Newtown Road corridor are very different than those on Nemo Park. The communities in SeaTac are very different than the communities on the ocean front. These are very different communities, very different socioeconomic communities. So they need representation on city council that speaks to those differences. And that's all I'm asking for this committee to consider. Thank you.
Thank you, Mr. Washington. Is that the last person in the public?
Mr. Chair.
Okay. Delegate Converse Fowler, is there anything you want to say to close this thing out?
Thank you, Mr. Chair. I just want to point out that the federal lawsuit, the case may have the same outcome as what is perceived here, but the issues are different. The Federal Voting Rights Act being the issue in the federal case. The referendum that was done in '94 that was referenced was actually in '95 sent to the General Assembly to be done and changed to their charter, saying that they would have only the people voting in the district. But that was changed. And then in '96, they did a new referendum that asked a completely different question and asked if they wanted to vote for all of the council members or instead of just the ones in their district. So that was very misleading. There has been proposals for referendum since then several times by sitting council members, and they've all, up until last year, been rejected by the council. And this is general legislation. It would apply to all localities. We don't want any locality to do this. It comes down to people, if you live in your district, they should elect you, not people outside of your district. How would it be if everyone in the entire state elected all the House of Delegates or all the senators, and they don't live in that district? So this really just comes down to an equity issue and a fairness issue.
Thanks, Siobhan.
Thank you, ma'am. Senator Servell and then Senator Spruill and Senator Servell.
Thank you, Mr. Chairman. So, this idea that we should wait because of the litigation doesn't hold water for me on this bill. I'm looking right here at a Virginian Pilot article describing the city council meeting where the referendum got rejected 5-6. And I don't see anybody who rejected it saying, we can't do this until the lawsuit's over. It went down 5-6, it says, because some members were concerned that the public didn't have enough time to get educated about this. It sounds to me like the public's been fighting about it for 30 years. I don't know why they need any more time to get educated. It sounds to me like you just got an ingrained majority in power that doesn't want to give up power, and that's what this is all about. And, Mr. Chairman, I think I also, I actually downloaded the complaint off Pacer and read it here, and it says that since the 1960s, when this was put in place, the percentage of minorities in Virginia Beach has doubled. It's now a third of the population, and in its entire history, it's only been able to elect 5 members to council. I mean, there's clearly some politics going on with this, and when a locality can't solve their problems, it's time for us to solve their problems. So I support the bill, and I think we need to pass it.
Okay, Senator Spruill.
Thank you, Mr. Chairman. The key is, Mr. Chairman, that why is it we keep hearing that the council is making a decision, and they refuse to have input from the citizens. Council got to stop doing that. And they've been doing this in Virginia for years. Reverend Gerb McCullough have said he named the areas like Seatock, Ella Jane Garden. All of those areas, Mr. Chairman, they're all a black communities. They will never be able to do it there. See, the key is this, and you look at the members on, the average member who was on that city council, been there for years, because you got 6 members been controlling the same members over and over again. Those 6 members have been controlling. This was given to me, Mr. Chairman, by a member of city council. And Senator McCullough, Senator Jen, the senator, she clarifies it up that there's a separation between those two. That takes care of that. It's time for Virginia Beach and other cities stop controlling this thing. They work for the citizen, and they got to have the citizen have input. This is the good bill, Mr. Chairman, and this will allow the people who live in that ward or this, whatever they call it, if they pick anybody, let them make the decision, not let outsiders make the decision for that ward.
Okay, the bill is before the committee.
I move report, Mr. Chairman.
Got a motion to report. It's been properly seconded. Are there further motions? Is there further discussion? If not, please open the roll.
Senator House proxy. As 8, no 6, 1 abstention.
Okay. The bill's reported. Congratulations, Delegate. The last bill on our docket is House Bill 2324. Delegate Watts. Her bill, that was the only one of the bills in this block that didn't pass on a partisan vote. It just had a few negative votes. Delegate Watts, if you could explain House Bill 2324, I'd appreciate it very much.
Thank you, Mr. Chairman. First of all, let me just note that its high number, 2324, is because it was introduced because I happened to have a slot when very disturbing news came out about one of the 8 citizens who have been appointed to the Redistricting Commission, where you saw years and years of inappropriate comments. That inappropriate is a kind word as far as I've looked at them. I can say at very least they're undisciplined, but they are also at their heart a number of racist and sexist, xenophobic, derogatory references. Now, the bill does provide then a means for the commission to remove a member. It's not whether or not the individual that sparked this bill before you should be removed. That's up to the commission. But we realized that there was no way that the commission could act to remove a member as the bill reads. For neglective duty or gross misconduct.
The standard is for neglective duty or gross misconduct. It requires 6 out of 8 votes. Is that correct?
That is correct. This honoring the same balance that the commission has been structured under to make sure that it doesn't have a narrow partisan focus to it.
Okay. I think we understand the bill. Are there questions of Delegate Watts? I apologize. Senator Peaks in queue. Yes.
Thank you. My question would be, is the gross misconduct while he is a member of the commission, or can the commission look back at something he did before he was appointed to the commission and say that's gross misconduct and remove them?
The bill does not stipulate that. The bill, by the protection of the extraordinary vote required, would allow the commission to decide in that extraordinary vote that the conduct does not reflect appropriately on the serious business of the commission to have a balanced look at redistricting.
Did that answer your questions, Senator Peake? Are there additional questions? Are there members of the public that would like to be heard on this issue?
Yes, Mr. Chair, we have Erin Corbett.
Okay, Ms. Corbett, is she the only one?
If you'd like to speak to the bill, please raise your hand.
Okay, Ms. Corbett.
Thank you again, Mr. Chairman and members of the committee. My name is Erin Corbett, again, speaking on behalf of the Virginia Civic Engagement Table. This bill ensures a process that is in place should the commission decide a commissioner needs to be removed for neglecting their duty or misconduct. Currently, there is no process in place to address these issues. This protocol should be created to ensure clear expectations are established, maintained, and followed by the commissioners. We ask for the committee to vote in favor of this bill. Thank you.
Okay, thank you very much. Are there others?
No, Mr. Chair.
Okay, the bill is before the committee. Got a motion and a second to report the bill. Are there further motions or further discussion? If not, please open the roll.
And Senator Donovan's proxy. According to this, he does. But go ahead and close.
Yes.
Ayes 9, noes 1, 3 abstentions.
Okay, congratulations, Delegate Watts. Your long wait has been paid off.
I've enjoyed every moment of it. Thank you, Mr. Chairman, members of the committee.
Without there being further to do, we turned an hour's work into 2 hours' work, and we'll rise.